and welcome back to our channel. My name is Kumar. I am a legal intern in LEXIS and Company. So in this video, we are going to discuss about the theory of territorial nexus. So starting from the basic introduction, distribution of power is an essential feature of federalism. Power is distributed between state and the center to legislative, administrative and federal authorities. Central legislative body plus state legislative body makes an legislative relation. Function of legislative body is to make law and power to make law includes power to give effect to the laws prospectively as well as retrospectively. The legislature has power to alter the laws respectively. So according to Article 245 to 255, legislation relationship is defined in two folds, that is territorial under Article 245 and subject matter under Article 246. So now coming on the main crux of doctrine of territorial nexus. Territorial means boundaries plus nexus means relation. Invoked under two circumstances, whether a particular state has extraterritorial operation, and second, if there is a territorial nexus between the subject matter of the act and the state making the law. It signifies that the object to which the law is applied need not to be physically located within the territorial boundaries, but what is necessary is that it should have a sufficient territorial connection. So now look at Article 245, extent of laws made by Parliament and by the legislature of state. Subject to the provision of this constitution, Parliament may make a law for the whole or any part of the territory of India. The legislation of the state may make a law for the whole or any part of the state. No laws made by Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. In the case of Valence versus Income Tax Commissioner Bombay, AIR 1948, it was held by the court that the company could leave an income tax on the entire income and not only on the portion acquired from India. The sufficient territorial nexus is presented before the companies between the company and India. In the case of A.H. Wadia versus Income Tax Commissioner, AIR 1949, Supreme Court held that in the case of sovereign legislative, question of extraterritorial or any enactment can never be arise in the multiple courts as the ground for challenging its validity. The legislation may offend the rule of international law, may not be recognized by foreign courts, or there may be particular differences in enforcing them, but there are questions of policy with which the domestic tribunal are not concerned. So now let's look upon the next case, that is State of Bombay versus RMDC, AIR 1957. The State of Bombay levies taxes on lotteries and prize competitions. It was held valid because there is a sufficient territorial nexus between the State of Bombay and Bangalore, as it was printed and published in Bangalore but has a wide circulation in Bombay. So Tata Iron and Steel Co. Ltd. versus State of Bihar, AIR 1958. It was held that there was sufficient territorial nexus and upheld the act as valid. Whether there is a sufficient nexus between the law and objects shall to be taxed will depend upon the phase and circumstances of a particular case. So there is no general definition of doctrine and what territorial connection or nexus is necessary for the application of the law to a particular object. For considering and the sufficiency of the territorial connection involves the followings. First, the connection must be real, and second, the liability shall to be imposed under the act must be pertinent or relevant to that connection. So I hope you find the video informative, so please like, share and subscribe.